Fritz really be serving today with these briefs. Sometimes I think about how much these lawyers on this case are working. I mean, to turn these oppositions around in the time that they're doing it with everything that's going on, they must be working day and night. So Wayfarer responded to Isabela Ferrer's opposition to Wayfarer's motion to seek an alternative means of service for her subpoena. What I really like about this reply is that it doesn't give in to the mudslinging. It focuses on the issue at hand, addresses it head on, and directs the court as to where it should go with the motion. While it can be really tempting sometimes to give in to the personal ad hominem type attacks that happen in these briefs, this shows that they are specifically narrowed in on the issue that they brought before the court. And the court, while it may not say it, will appreciate it. Wayfarer acknowledges that the opposition was an inappropriate attack on Justin Baldoni and his counsel, contrary to that August 8th order that the judge ruled for decorum, but doesn't really get into the nitty-gritty of that because it's not at issue. All that is issue for this motion is Wayfarer's request to serve the subpoena by alternative means, and they address that specifically. At the outset of a case, there's something called initial disclosures that are exchanged between the parties that essentially says, these are the witnesses that we expect, these are the number of depositions we expect to take, not necessarily who, but the amount of discovery we expect. It sort of lays out what the parties foresee the case is going to entail. But one of the specific things on there is the witnesses that are identified. Typically, you include how you would reach them. If they are friendly witnesses and the lawyers that are stating them as witnesses would say you can reach them through us. Otherwise, there would be an address that you could reach those parties at. So what we learn here, despite some of it being redacted, is that Lively disclosed Isabela Ferrer as a witness and disclosed an address for her in their disclosures. So this whole runaround about how they didn't do their due diligence to find an address is sort of nothing because they relied on the address that the Lively party provided. And furthermore, there was a Lively subpoena to Ferrer that was responded to, and Michaelman, the attorney that's appearing on behalf of Isabela Ferrer, presumably accepted service on behalf of Ferrer. We don't know exactly if they personally served her or not, but there was the same attorney and there was a subpoena and there was a response to that subpoena. And the subpoena that the Wayfarer parties issued against or to Ferrer was including documents that were not part of the production that Isabela Ferrer produced to the Lively side. So either it was a little bit more expansive or it looked at something from a different lens. Whatever it be, the documents that were sent over under the Lively subpoena were not sufficient to answer the questions that the Wayfarer parties have with respect to documents, and they are entitled to seek those documents, which is why they sought a subpoena. To the extent that Isabela Ferrer feels that the requests are overbroad, she is entitled to object or move to quash the subpoena or limit it in some way. But this fight is about accepting service, and her counsel is refusing to do so, which honestly I think the court is going to find annoying. Given the headlines that we saw yesterday, I'm even more convinced that this was done in an effort to create publicity that would be beneficial to Lively. That publicity is headlines that read, Justin Baldoni is harassing Isabela Ferrer. That's why they didn't name the Wayfarer parties. That's why they used the word harass a dozen times. Those are the headlines that they wanted to come out. The most interesting piece of this reply letter is that the Wayfarer parties offer something that you don't typically see. They offer that they will stipulate, meaning agree, that neither party can use the communication involving Miss Ferrer in trial as evidence, what have you. They agree that they won't use it if the other side agrees not to use it. Effectively, this solves her problem, which is that she doesn't want to be involved in the lawsuit, and it places Lively in a position where they will have to decide whether or not they want to agree to that. It's signaling that the Wayfarer parties don't deem the whatever evidence there is of communications between Ferrer and Lively, what have you, to be that helpful to them or hurtful to them. They're willing to do away with all of it. I imagine that Lively would want to use some of the communication if it's beneficial to her, so she's going to have to make a call. Her lawyers and her are going to have to make a call if they're willing to forego using anything that could be helpful to them, at the risk of not having it at all. This is really kind of putting Lively in a situation where she has to make a call. Either let it all out, including anything in there that could be damaging even to Isabela Ferrer herself, or agree to walk away from potentially helpful evidence to avoid implicating other people. If Wayfarer can't get the documents that they sought from Ferrer, I can see a motion in limine, which is a motion that's filed right before trial, asking the court to exclude any evidence from this witness because they didn't have the opportunity to seek all of the records or appropriately discover stuff from that witness. And so it would be prejudicial to have a witness that did not comply with a subpoena. I kind of hope there's a hearing on this just so I can hear the judge's questions on this. But we'll see. Probably just get an order.